Hello, everyone. Welcome to this panel on using old tools in new ways, the new economic world order. My name is Céline Lévesque, and I'm honored to moderate this panel from Ottawa. I'm joined today by three amazing speakers. I'll introduce them briefly before presenting the structure of this panel. First, we have Rose Ramo. Rose is the founder and partner of the Ramo law firm in Washington, D.C. She acts as counsel, mediator, arbitrator in international disputes. She's a fellow arbitrator and ICC court member on behalf of Haiti. Then we have Eric de Brabander, full professor and director of the Grotius Center for International Legal Studies at Leiden University Law School. Eric is also a partner with DMDB Law. He's been appointed as an arbitrator in commercial arbitration, acts as an expert in international proceedings, and as counsel in investment treaty arbitrations. Then we have Pak Parkhurst, former Associate General Counsel litigation at Koch Companies Public Sector LLC. He's recently retired from that position. He has actively litigated and tried cases in a large number of US jurisdictions, as well as international arbitrations, including a large bid claim. Corey also advised Koch companies on a variety of public international law issues. So I'm very grateful for them to have joined this panel. I also want to thank Ansel and Robert Volterra for the invitation and our sponsor, Deckard LLP. So I'll take a few moments to explain the structure of this panel, which will be divided in three. One will be a brief 5-minute introduction by each speaker related to the theme of our panels on the use of sanctions, pressures put on institutions for change, new ways to use trade agreements to achieve different objectives, and the like. Then we'll have a segment, really a debate that will pit against each other, two of our speakers, with the third one being a referee. And I want to note on the debate section that this is really role play, so the position taken by our speakers are not to be attributed. And then we hope to have enough time, about 15 minutes for Q&A. So please do send us questions. So we are ready for our first segment. So I'll give Corey the floor.
Well, thank you very much, Celine. And I also want to thank Ansel for the invitation to participate in this wonderful panel with my panel members. What I want to talk about today is the U.S. sanctions regime with respect to Venezuela. In particular, how the U.S. sanctions has evolved over time such that it's so easy to implement sanctions that it's created an environment where really unbelievable things have happened. And under the circumstances, people in states just think they're commonplace. The other thing that's happened is there's very perverse incentives now because of the conflicts within the Ashland regime. I want to point out that in 2014, the United States enacted the Venezuela Defense of Human Rights and Civil Society Act. It was a very narrow act focused on improving the human rights of the people in Venezuela. However, since that time, given the ease of implementing sanctions via the executive order, there has been a multitude of additional sanctions that have been issued by various departments against Venezuela, including the Treasury Department imposing over 144 sanctions against particular individuals related to Venezuela. The State Department has over time revoked hundreds and hundreds of visas linked to Venezuelan nationals. And also the President Trump's administration has issued sanctions via executive order against the government of Venezuela, the central bank, and also PDVSA, the government-owned oil company. So what has happened is we have an environment where these sanctions are so numerous and so complicated, and it's not just the U.S. regime; it's other states as well. That we have a very complex environment of interrelated sanctions, and sometimes these sanctions are at odds with each other. So one thing I want to talk about is something weird that happened, something extremely odd that was taken as commonplace. An analogy would be if the U.S. House of Representatives lead Nancy Pelosi came out this afternoon and pronounced herself the new righteous president of the United States. I think we'd all look at it and say, well, that's an internal U.S. issue. It's weird, it's odd, it's unbelievable. But in January 2019, that's exactly what happened. A politician, Juan Guaido, who was in the Venezuela government at the time, came out and announced himself the president of Venezuela. Did people think that was weird? Some did, but within 48 hours, a multitude of states came out publicly and acknowledged him as the rightful president. Did that solve anything? No, it didn't. It created a great deal of havoc. And now, across the globe, there are international organizations, international arbitration panels, judges who are now having to deal with the issue of whether Guaido is the proper president or Maduro is the proper president. Again, I think this is the result of not just the large regime of sanctions by the U.S., but also the global economy as with respect to sanctions against Venezuela. Next, I think it's created perverse incentives as well. There is a case in the United States by Crystalex Corporation. Crystalex is a Canadian organization who owned a gold mine. It was expropriated by Venezuela. Crystalex brought an arbitration. They ended up with a very sizable award. They're pursuing collection in the United States. And in the United States District Court and the Appellate Court, Crystalex convinced the court that PDVSA was the alter ego of Venezuela, allowing Crystalex to go after assets of PDVSA. Normally, a sanctioning company or sanctioning country like the U.S. would promote that. It achieves the exact same pressure as the sanctions. But here, given the fact that Guaido is in charge, it was at odds, and it was in fact contrary to what the U.S. was interested in. So they had to issue sanctions to prevent that execution. So in short, what I'm saying, the old tool of economic sanctions being used in today's way is not progress, as I see it. And with that, I turn it back to you, Celine.
Thank you very much, Corey. We'll turn now to Eric.
Thank you, Celine. Thanks also to Asil and to Robert Volterra for having put this panel together. I will focus on the law relating to foreign investment and more specifically the proposal to establish a multilateral investment court. So the idea is to briefly look at whether we are indeed dealing with old tools that are being used in new ways, and then of course whether we're heading towards a new economic or investment world order. The idea, I think, is also to have a look more generally at whether everything that's happening now, the reform proposals in international investment law, are actually indeed something that you can term as progress, something new, or in fact is actually a regression, it's a return to the past. Very briefly, two points on the reforms. The first one is, of course, that the idea of an investment court, multilateral investment court, that was launched in 2015 approximately by the European Commission. The idea was to replace arbitration by an investment court, and then in the next second step to sort of replace all investment courts that are treaty specific by one multilateral investment court. On the substantive side, we have also seen over the past years a sort of what I will call a recalibration of certain investment protection standards. And it has not only resulted in formulations of fair and equitable treatment, expropriation, but also the inclusion of new norms that relate to human rights, environmental obligations, etc. And a famous example, of course, is the recent Pan-African Investment Code, which is, of course, still a draft, sort of model. But this is quite interesting recalibration. Now, if we look at what these reforms or reform proposals say, again, whether this is progress, regression, or a sort of conservatism, I think you could easily say it's probably both. It depends on how you look at it. This is, of course, not very satisfactory. It's also not very challenging. So I'll offer some insights and some ideas on how to look at this. The first thing, of course, is that there is, to a certain extent, and I'll come back to this very briefly, a return to the past. Right? But the thing is, you never have a full return to all tools. The old tools, if used, are it's a bit like fashion trends, right? It sort of reminds us of something that existed a couple of decades ago, but it's not exactly the same. It's modernized, it's perfected, it's a sort of branded old tool. And I think this is quite important to keep in mind, also in light of the fact that we are witnessing a very cyclical evolution in investment law and arbitration. There have always been periods of sort of optimism, trust in the system, followed by periods of challenge to the legitimacy of the system. And this actually goes hand in hand with sort of more internationalistic and nationalistic tendencies. Now, if we look at the substantive reforms, I think they are not as such a radical departure from what we now have. Again, I call them more recalibrations. They're, of course, and this is something that will be valid throughout my presentation, they're, of course, very heavily influenced by state interest and driven by state interest. They are responses to developments, decisions of arbitral tribunals that either went beyond the intention or did not conform to the intention. But we're not going back, for instance, if we look at fair and equitable treatment, to a sort of nearer type of international minimum standards, right? So there is still a lot of newness in the formulations and in the reformulations. If we look at procedural reforms, it's, of course, a bit more complex, also because the criticism there is on the legitimacy and not only state-driven. Right? So a bit of a combination of general legitimacy issues and then state interests. We should, first of all, in relation to the latter, not forget that the court as such is not a very sort of progressive idea that the EU came up with. It's a relatively self-centered mechanism that was devised to also counter the fact that EU member states were increasingly respondents, that you had intra-EU BIT claims, and that the EU itself was more and more looking on investment arbitration from the other side and from the claimants. Now, if you look at the mechanism itself, I will finish here. There is a bit of a paradox I want to highlight. The first thing is that it's a sort of modernization, but at the same time, arbitration as such is the most ancient form of dispute settlement between states. So the idea of putting in a court is not an old tool, it's something completely new. Courts are rare devices in international law. And I think what is interesting also is that the court itself brings back state interest, right? Or state control over certain features. And I will point simply to the fact that here again, the states fully control the procedure. They fully control the appointment of those who decide. So there is throughout, I think, the entire reform and the reform proposals, very heavy influence of state interest. But I'm not entirely sure that this causes a radical change to what we now have. I call them really more perfections, recalibrations, and who knows, in 5 years, we'll have a complete other recalibration. Thank you.
Thank you, Eric. Now, Rose.
I have to remind myself that I was on mute. Okay. Thank you, Celine. And I join Corey and Eric and yourself regarding thanking Robert and ASO for this opportunity to be here today. My presentation will be mainly focused on Africa. And Eric just mentioned the Pan-African Investment Code. That's going to be the main topic for me, presenting all ways in that African states are using now to handle the new economic world order. By doing so, I have to go back a little bit with regards to the first generation BITs that we all know that was signed back in the 1990s and 2000. And Africa itself has over 700 BITs that were signed between African states and the developed world. And Africans have been disenchanted at the outcome of some of these massive awards, sanctions, and they felt as if it was another form of colonization. And I believe that by going with the Pan-African Investment Code, which is essentially the first continent-wide African model investment treaty, they have taken the old ways that were articulated in the first generation BIT, such as the most favored nations, clause, national treatment, fair equitable treatment. They have used these clauses, but not necessarily following them the way they used to be. And they actually put in the Pan-African Code specific exceptions to highlight that. So in the interest of time, I'll tell you briefly that it's very important to really see what the Pan-African Code says. It says it will regulate all aspects relating to investments within the territory with a view to promote sustainable development. So now Africans are saying, no way would the 2 pages BIT work. It has to be an investment that would promote sustainable development throughout the code. That is the theme. That is what the code is trying to promote. And we see that because the code itself specifies what is the definition of investment. The definition of investment under the code is the exact Salini test, and it even mentioned the word Salini in it, and which is very interesting. And the second thing that we see in the Pan-African Code is also give straight rights to the state to bring counterclaim, which under exceed you can still bring, but we know sometimes tribunals, most of the time, would reject the counterclaim from the states. But under the Pan-African Code, investment code, it's clear that now you can bring sort of a counterclaim against the state if there is any violation. And it is so important to also see that the PEC reserved and then dedicated an entire chapter to describe what are the obligation of the states. And some of these things that the code mentioned is the framework for corporate governance, socio-political obligation, bribery. So no way could an investor come and bribe public officials. Corporate social responsibility, obligation as to the management of natural resources, business ethics, and human rights. So that's entire chapter 4. And where there is any possible violation from an investor, the state will have a right, an inherent right, to bring a counterclaim against such investor. So now what really happened with the MFN is that there are exceptions. For instance, Article 8.2 says that AU member states can adopt measures that are designated and applied to protect or enhance legitimate public welfare objectives such as public health. So I think my time is up, but it's very interesting to see how Africans now are using the new, the old ways, but into the new economic order. And we see the same thing happens with the recent trade agreement that was signed by 54 countries, except for Eritrea that did not sign. Thank you.
Thank you, Rose. That was even a bit below 5 minutes. So thank you for that. These were very insightful remarks, and we can follow on the discussion during the Q&A if the participants would like. But before that, we'll have a bit of a debate. So I'll remind you of the rules. So I'll put 2 questions to our debaters. So the first person will argue about 3 minutes, giving arguments for. Then the person against will also go for 3 minutes. And then the third speaker will be kind of a referee and give some insightful comments. So again, these are not for attribution. So this is really a role play. So keep that in mind. So for the first question, we'll have Corey and Eric facing off and Rose being the referee. So the question is the following. Is a government ever justified in criticizing and putting pressure on an international institution, for example, by blocking nominations or withholding funding in order to force that institution into reform? We can think of a US policy vis-a-vis the WTO appellate body, but more recently, we could have also the example of the WHO. So I'm gonna give the floor to Corey.
Thank you, Celine. I am in favor of this particular proposal. And first, I'd like to point out that governments do not divest themselves of their sovereignty or their independence simply by entering into a membership with an international organization like the WTO or WHO. They retain all of their independence and also their obligations to their country to promote the policies that best fit their needs. I would also point out that the actual governing documents of independent international organizations such as the WTO and WHO make no attempt to limit a particular government or state's rights to express their views and, quite frankly, insert influence upon that particular organization, particularly if the policies of the organization had become so contrary to the member states' interests that it becomes necessary to attempt to correct those policies and seek reform. And also, given the fact that states protect their sovereignty and attempt to avoid waiver, it is very clear that in these documents of membership, there is no words that would even come remotely close to waiving any of its independence or sovereignty as a state. I would also point out that part of the value and strength of these organizations is the independent view of the various members themselves. And if they're unable to seek and obtain some sort of reform, getting the organization back on track, so to speak, it's exactly contrary to the goals and expectations of the organization itself to seek to draw on the knowledge and experience of the various states. So for this particular proposal, I am in favor. Thank you, Celine.
Thank you, Corey. Now, Eric.
Thank you, Celine. I have been asked to be against, so I am against. I think one of the important points, of course, is that once you create an international organization, they become fully independent legal persons. And one of the expectations, therefore, is that the organization starts, of course, leading its own life. And this is perfectly normal because it separates itself from the states. This relates to a second point I want to make is that, and this may sound a bit naive, but the whole international organization idea is to cooperate, is to establish mechanisms by which states speak to each other. At that point in time, it becomes also slightly less relevant what one particular state wants, because the overarching idea to cooperate, I think, in this case, takes precedence. The third related point is that as a consequence, if you seek as a state reform changes in certain courses of action or entire reforms of the organization, it is, in my view, better, of course, to pursue these within the structures of the organization itself, the mechanisms that have been put in place in the organization, rather than seeking to resort to more old school diplomatic, financial, and economic pressure tactics. And I want to make a final point in relation to the appellate body of the World Trade Organization. There, I think there is an additional element, that is that it is a quasi-judicial organ. It functions a bit like a court. It's not a court, we all know. But you can expect there also that a judicial organ will fully abide by the principles of independence itself, judicial or quasi-judicial independence. And I think here it's not only better, but it's also probably desirable to say that a court, tribunal, quasi-judicial organ interprets its mandate in light of its constitution, but also in light of whatever is needed, and again within the constitution, outside of the specific interests of states. So I will finish here. Thank you.
All right, thank you to you both. I forgot to mention that we are allowing rebuttals. So I'll let Corey have 1 or 2 minutes to say what he thinks of Eric's arguments.
Well, thank you. Thank you, Celine. And my colleague Eric makes excellent points. I have 2 brief points in rebuttal. The first would be that international organizations owe their very existence to the agreement of states. And I recognize that the goal would be that they live their own life, but the life would not and should not take the precedence over the sovereignty and wishes of the individual states themselves. The second rebuttal point is Eric made an excellent point about the World Trade Organization Appeals Board. I think meddling in any type of quasi-judicial decision is not appropriate. However, if the policies of the international organization are skewed and wrong, the appeals board will be issuing rulings based upon and following inaccurate, incorrect, and flawed policies. So ultimately, the influence that states should have will and should flow down to the appeals board through the normal process of precedent and regulation, not through meddling in a particular matter.
All right, thank you. Eric, your rebuttal.
Yes, very, very briefly, I think Corey also made excellent points, not only in the rebuttal, but also, of course, in the first presentation. I do still think that I see the point, of course, that there is this tension between state interest and the interest of the organization. I'm still convinced that once you create an international organization, the better way, and again, in light of cooperation, is to seek reform, seek changes within the structure via cooperation, communication, rather than harsh individual decisions. I think it's also a question of efficiency. In my perspective, it creates a better future for the organization also, if states are, again, talking to each other within the mechanisms established to that effect.
All right, thank you both. Now, Rose, you get to referee this debate.
I think both Corey and Eric made excellent points, and I would just add that put it in context in the case of this pandemic. I think if a nation state is losing faith in the international organization, I believe putting some kind of pressure may be justified if there could be proof that they've actually tried, based on what Eric suggested, to negotiate or to discuss the matter. So But other than that, I think both parties here have excellent points, and I applaud both of them.
Thank you. You're all being very diplomatic. All right, moving on to our second question for debates, which is really a timely one. Are governments justified in adopting protectionist measures in a time of pandemic? So we've heard a lot about different states adopting measures that can be qualified as protectionist. Is it justified? So for the proposition, we have Rose. Against, Corey and Eric will provide some comments. So here you go, Rose.
Thank you, Celine. I will be presenting some arguments in favor of the protectionist measures. My arguments will be on three phases. Number one, I believe that dependence on foreign aid products, including medicine, can put the nation at a security risk. So the second point I have is that there is an inherent police power that is given by the states. The preservation of the public health has historically been the responsibility of the state and local government. And third, even if we were to look at this from an international view, we see that under customary international law, the International Law Commission articles on the responsibilities of state would provide certain defenses in the event that the state is sued based on these protectionist measures. So some of these defenses would be force majeure, distress, necessity, countermeasures, self-defense, and even consent. With respect to this pandemic, the last three defenses probably won't be available, but I think force majeure, distress, and necessity could be a valid defense for the state. So going back to my first point, it's clear that in the case of the US, we see the US Food and Drugs Administration reports nearly 40% of finished drugs, roughly 80% of active pharmaceutical ingredients are manufactured in more than 150 countries overseas, primarily China and India. And the coronavirus has made clear just how dependent the United States supply chain is on China for medical products. So I believe that it will be in the US interest to get back the ability to produce the medicine at home and have more security. So for that, having such a protectionist view for medicine in the United States is probably a good thing. And with respect to the police power is very broad, encompassing not only traditional public health, but environmental law and any other areas where government acts to protect health and safety. And I don't know if my 3 minutes is gone, so I'd like to stop here and leave some for rebuttal.
Great, thank you.
Thank you.
Again, right on time. So Corey.
Thank you, Celine. And at the risk of being too diplomatic, I think Rose makes excellent points. And I do agree that there are numerous reasons for a state to implement protectionist measures, for example, to protect intellectual property. And those same reasons may exist in the circumstances of a pandemic. My point, and what I'd like to propose, is that it is not justified in certain circumstances where the protectionist measures would result in an increase of the severity or the spread of the pandemic. My suggestion, my argument is that a state would not be justified in implementing such protectionist measures. For example, if a state had more than enough vaccines for its own population to then implement protectionist measures to prevent excess vaccines from being exported to other needy countries. I think while potentially legal, it is not justified. Also, I would say that where protectionist measures violate various international treaties or conventions relative to the prevention of the spread of pandemics, again, that might not be justified. For example, while under the World Health regulations, a country may take an act that could subject it to recourse under those regulations. But the recourse is subject to consent of the violating party. Now, while that could be set to be appropriate and legal under the structure of that particular regulation, I would still argue that violating a treaty, which ultimately results in human harm or death in other jurisdictions, I don't think that is justified. And as you might tell, I'm focusing on the word justified and distinguishing that from necessarily legal or appropriate under various international treaties. Thank you.
Thank you, Corey. Also very disciplined. Now we have rebuttals. Rose?
Yes. I think that the argument that Corey made with regards to not allowing a state to maintain the monopoly of medicine could injure another state is well founded. However, the dependence factor, I believe, outweighs such measure, because when we look at foreign manufacture of medical products, that's very critical from a strategic national stockpile, and that are subject to the same quality and safety concerns. So, but dependence on the foreign countries for drugs used as medical countermeasures also can leave Americans vulnerable to chemical and biological threats, among others. So I think for that, we need to be very, very careful. That's why I would go back to my proposition. It should be justified.
Corey?
Well, again, Rose makes a great point. I think the difficulty is when you get to specific instances and specific facts. Again, for example, where the national security of the United States is in no means under threat, and a circumstance where there is more than enough of the vaccine to go around. I think the argument is a bit strained where the government chooses to essentially hoard products and potentially services that could, from a world perspective, a global perspective, help minimize the harm and limit the extent of the
pandemic. All right, thank you to you both. Now, Eric has the last word.
Yes, thank you. Well, I have to be fully honest, excellent arguments by both Rose and Corey. I think two issues that strike me. The first one is, I think the interesting part is that we have actually on both sides very interesting and very good legal arguments that can be made. I do have some sympathy for the idea that Corey has expressed, that is the sort of bad faith abuse of rights notion. I think that you, of course, have rights, but there is a limit to what you can do with those rights. At the same time, and I'm Belgian, so I'm by definition diplomatic and seeking compromises, I do see very much the point that Rose made on circumstances precluding wrongfulness. I mean, if ever there are situations where you can use things like distress, necessity, force majeure, it's probably also in this kind of situation. So I think that definitely also is a very valid point, and I'll leave it here.
All right. Well, thank you, everyone. We actually have exactly 15 minutes left for Q&A. So thank you for this. So I've received about 5 questions so far. So I'm going to put them to you. I'll mention the name of the person asking the question. I apologize in advance if I mispronounce some names. So since we have a few, I'm going to ask our speaker also to give rather short answers, and you don't have to answer everything. So I'll look to you to decide which question you want to answer. So the first one from Jingxi Huang: would using old tools in new ways not envisaged before, for example, reading in new norms, environmental norms, threaten the legitimacy of old tools? I can ask it again if it's a long one. So would using old tools in new ways not envisaged before threaten the legitimacy of the old tools? For example, when you're reading in new norms, for example, environmental norms into old tools. I'll start with Corey.
Yes, I might start with that. I think it's a very good question, and it's getting the point of somewhat of reading the old tool in the context of when it was written. And I think the better way to look at it would be that these old tools, as written, are meant to be, in a lot of respects, living documents, and must be interpreted in the context, in the current context, as opposed to the old circumstances. You must give consideration and context to when these were written, but things change over time. For example, if you're reading something that refers to traveling from point A to point B, and that meant taking a horse and buggy, that does not apply to what is happening in the current situation. So I'm not sure if I really answered that question, Celine, but maybe one of my colleagues could add.
Yeah, no, that's a great start. Does anyone want to add?
I just wanted to say, in the context of the my presentation with the Pan-African Investment Code, I would say that the old tools did not really help Africa, which is why the Pan-African Investment Code, they tend to draw from the old tool, in a sense, either to make it better in the new way, new economic world order, or to just remove it altogether. For instance, when we see the FET clauses, which is the fair and equitable treatment under the PEC, it's totally gone. And the reason for that, African states find that tribunals, in interpreting the fair and equitable treatment, there was no, I would say, consensus. It differs from tribunal to tribunal, and Africans just didn't want to bargain. So that's one way to think about how the PEC now is coming as a protection of natural resources and sustainable development, and that's key.
Thank you, Rose. Eric, you want to jump in?
No, it's fine. I think for the sake of time, I'll leave it here, and we can go to the other questions.
All right. Actually, the next question is related to what Rose was just saying in part. Question from Shi Hu. How does the pandemic affect investments in Africa? What tools should be used / reformed to deal with the new changes? So again, how does the pandemic affect investments in Africa, and what tools should be used, reformed to deal with these new changes?
I think the pandemic is affecting all investments, because if you look, for instance, because the governments are making deciding which work is essential, which is non-essential. So arguably, if you have an investor in Africa and in a particular government decide that mining is not essential, so you stop mining for months, and you are going to have a problem. What really determines essential or non-essential? Whether or not we have some tools to deal with that, I am not privy of it. Maybe Eric can jump in, or Corey, but I think all investments will be affected, and whether or not you could have a valid treaty claim would be the whole thing, and whether or not the articles that I've mentioned before with the defense of force majeure, consent, and distress would come in as a valid defense of the state to implement those force measures.
Okay. Eric?
Yeah. No, I fully agree. I think the pandemic hits every investment, not only Africa, it's everywhere, Europe. And I think before we start thinking about reforms, I think we have to first wait and see if there is a successful claim, as Rose also explained. I mean, it's not a given that you will find violations of the treaty, and that even if you find violations, that you can also not rely on circumstances precluding wrongfulness. So I'm someone we had a former prime minister who we call the plumber, because he used to say, don't fix the problem before it arises. And here, before we start thinking about reforms in light of pandemics, let's wait and see what happens with claims, and before we need to see whether changes are made. I think changes have already been made on interpretation of FET, on expropriation, and then, yeah.
Thank you. Corey, you want to add?
And Eric, is that whether there are valid claims or not, to the extent that there are reforms that could be made to actually prevent the impact of the pandemic, which ultimately affected all future foreign investment, would be wise. I know some people have suggested a stronger international convention on the prevention of pandemics. And if that could be incorporated and implemented, such as to curb the flow and spread of the disease faster, I think that would help across the board, but that may be decades down the road.
Thank you for this. So we move to our next question on sanctions from Sally Ishun. US sanctions were briefly mentioned. What are the speakers' view on potential international adjudication on unilateral sanctions? Example, ICJ US versus Iran GCPOA case. You want to start with this one, Corey?
Sure. I'd actually like Eric or Rose to start with this one.
I'm happy to start. But there's one thing I learned, that there's never to predict the outcome of an ICJ case. I find it in this particular case even more difficult, to be fully honest, because it's not only about the sanctions. I mean, it's really about the GCPOA and much more than just the legitimacy of the legality of sanctions. And to be fully honest, I wouldn't dare to imagine what the outcome will be in that case. It depends on so many separate things. So I was happy to take the floor first, but the answer is very disappointing, I'm afraid.
No such thing. Who's next?
I think Corey wants me to say a few words, and I will say that I agree with Eric, because when we sit in our office and look at these cases, we have no way to know exactly how the tribunal is going to decide. So I don't think we can make any prejudgment as to the outcome. I think it would be unwise to do that at this point. Thank you.
Well, Selena, I was hoping Eric or Rose would have the answer to that. And I didn't think there was one. The only point I would make is the actual effect of the sanction, especially when it's done by executive order, can be very quick and immediate, where an adjudication could take years to seek redress. So sometimes I'm not sure it matters what ultimately happens, because the harm has been done and the impact has been felt.
All right, thank you. Question from Angelina Kolaki. which existing tools should be reinforced to better accomplish corporate social responsibility in the investment area? So CSR in the investment area. Which existing tools should be reinforced to better accomplish that?
I can start, unless Rose, you want to.
Go ahead.
Go ahead, Eric.
Thanks. So the interesting thing about CSR is I have never considered any of the existing CSR tools to be very or extremely efficient, in all honesty. There was, if I remember well, in the famous Multilateral Agreement on Investment in May in the OECD, the idea was to link the OECD principles on CSR to the investment treaty. It actually never materialized. Not only the treaty, so we don't know how this would apply. So I think we'll probably have to wait and see what the proposal of what they call binding instrument will be. And aside from the existing norms that you have, for instance, in the bike that Rose has explained, specific provisions requiring investors to abide by CSR obligations is probably the best thing you can have now. But as standalone documents, they have, of course, a very important effect, but it's not necessarily a legal one. So I find this tension between the non-legal nature and the incorporation always a bit difficult. Yeah.
Thank you. Rose?
Yes, I will add to this. Having lived in Africa for a number of years and been a Fulbright scholar there, and when I dealt with the CSR, it was very interesting. Just as Eric mentioned it, it's not a forced situation where you can actually tell a company you must abide by, and they would tell you, well, we're being nice, and our corporate social responsibility is to construct or build a nice crèche for the ladies down the road because they need a place for the children to go to school. But meanwhile, you would see situation where the community is complaining about some form of harm that's been done, and they actually think, which I believe is very disrespectful from a cultural standpoint, the corporation would think, oh, I'll just give money, we'll have a new crèche. Oh, you love football, so we'll build a football field. So, and that's how they have dealt with corporate social responsibility. And just like Eric said, I don't think we have an actual tool, but I think what's important, what could be reinforced, like in the Pan-African Investment Code here, is that Chapter 4 is dedicated to the obligations of the investor. That's very important, at least for the PIC. And if there is any violation into all these sections I've mentioned earlier, such as the corporate governance, social political obligation, bribery, management of the natural resources, and business and ethics, if there is any violation thereof. And what the PEC does now is to be able to file for a counterclaim against such investor. But any tools, I don't believe we have that.
Ari, you want to add a word on this?
I might just briefly, just from an investor's perspective, when it comes to social services and human rights, I think from an investor's perspective, anytime a country can be more precise and more transparent about what the requirements and needs are at the front end, it's much more inviting for a foreign investor. Right now, I don't think the old tools provide that transparency. While there might be domestic laws, ultimately where investors might get in trouble is where after the investment, the state looks at UN guidance and incorporates that not by statute, but just by interpretation into their domestic laws. So all of a sudden, an investor who thought the playing field was a soccer field, all of a sudden they realize it's a golf course, and they don't understand what the rules are. And unfortunately, they have already violated something without knowing what they're getting into.
Thank you. So we have.
May I add something, Celine?
Yes, please, Rose.
Absolutely, Corey. I agree with you. And that's why the PEC tends to solve that by dedicating an entire chapter 4 on the obligations of the investor. So arguably, if any investor is going to enter into a concession agreement and a state of under the AU would take some provision of that or even mention the PEC in its preamble, that would provide some kind of understanding that they intended that investor to abide by these rules under PEC. Thank you.
All right, thank you. So we have 5 minutes left. So I'm gonna suggest maybe one last question. I'm sorry, won't be able to get to all of them, but I'll ask a final question and we'll see where we land. So from Richard Weinerman, can we find a working balance between protectionism and open markets for services, especially for maritime, transportation, and professional services? So I can ask it again quickly. Could we find a working balance between protectionism and open markets for services, especially maritime, transportation, and professional services? Who's going first?
I'm from a bit of a libertarian background, so my initial reaction is open markets and not protectionism. However, as I mentioned in our debate, there's always appropriate circumstances for certain protectionist measures, particularly in protection of intellectual property. In my view, the balance should always be leaning toward open markets and free markets, allowing the free trade of both goods and services. I think ultimately the markets will balance out. And I think too heavy a hand on protectionism ultimately creates ripples that harm the global economy, not just the economy of the state implementing those measures.
Thank you. Other views? Rick, Rose?
No, I can only side with Corey on this. I think it's probably exactly what I would have answered.
All right, Rose?
I just want to say to the person who asked the question, that part of the exercise was just role playing. So I concur as well. Corey hits it right on. So I will not go against such balance. I think it's the best thing we would have given circumstances. Thank you.
All right, so I don't think we have time for another question. So again, apologies to those who are in the lineup, but I want to take this opportunity to thank our great speakers who went along with our role playing and provided very insightful remarks. I want to thank again our sponsor, Deckard LLP. And we look forward to seeing you during other session of this virtual conference. Thank you all.
Thank you all.